Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're talking about originalism and how it relates to the Second Amendment. I'm joined today remotely by Professor Jake Charles of Pepperdine Law School, a Second Amendment expert. Professor Charles, welcome.
Thanks for having me, Joel.
No, it's our pleasure. And why don't we start things off with what is originalism?
It's a good question. In general, what people mean when they talk about originalism is something that falls within a family of theories that says we ought to interpret the Constitution by looking backwards about what someone in 1791 or 1787, when the Constitution was written and when it was amended, what those people would have thought the provisions meant at the time. And although there are different varieties of what we should look to, should it be the intentions of the framers or writers of the Constitution? Should it be the understanding of the ratifiers or the public meaning to individuals at large? All of those different theories of originalism, or at least most of those theories of originalism, take two kind of theses as their core. One is what's called the fixation thesis. And these theses were spelled out by an originalist scholar named Larry Solomon. And the fixation thesis says that the meaning of the Constitution, the meaning of provisions in the Constitution is fixed at the time of ratification. So whenever those provisions were included in the Constitution, that fixed the meaning of the words. And the second is the constraint thesis and the constraint principle, which is that judges today, when they're applying constitutional provisions, ought to be bound by that original meaning, that fixed meaning. So they shouldn't update the Constitution based on modern values and modern preferences, but instead should defer to the original meanings by those who enacted the provisions at issue.
When you say fixed at the time of the ratification, is that give or take a few years, or is it at the time of the ratification as a decade?
Right, yeah. There's a variety of problems about how to recover that actual meaning about when we should be looking to. Most originalists would say that there can be evidence from a few years, a few decades, maybe even afterwards that might help shed light on what was meant at the time. And I think most originalists would say that the meaning of words that were written and ratified is not changing dramatically within a couple of years. So if we have evidence from, the 5 to 10 years afterwards, that's pretty indicative of what the words would have been taken to mean at the time the provisions were put into the Constitution.
Well, that's originalism. And how does it relate to gun rights, specifically the Second Amendment?
It relates because the Second Amendment is one of the few constitutional provisions that has, since the Supreme Court first started getting involved in the area, been pretty consciously interpreted with an originalist eye. So it wasn't until 2008 in District of Columbia versus Heller that the Supreme Court first gave a conclusive interpretation of the Second Amendment, and that decision has been hailed as one of the most self-consciously originalist opinions by the Supreme Court. It was written by Justice Antonin Scalia, who was himself a self-professed originalist, and the opinion is written in such a way that the court purports to be trying to recover what the Constitution would have meant, what the Second Amendment in particular would have meant to those in 1791 who ratified the Constitution. And even continuing with the Supreme Court's most recent Second Amendment case, New York State Rifle and Pistol versus Bruen in 2022, the court there was doing something that it would probably describe as originalist. It said it was looking to a historical tradition and history to determine what the founding generation would have understood the Constitution to mean, in that case with respect to publicly carrying guns, whereas Heller was about carrying guns in the home. But both decisions were appealing to history and self-consciously saying that there was some meaning that was fixed at some point in time previously that we today as judges have to defer to.
Yeah, in Bruen, would you say that the test that they created, the text, history, and tradition test, is that in some ways enshrining originalism in how gun laws have to be evaluated?
I think that's right. I think at least that's what Justice Thomas, who wrote the opinion in Bruen, would say about it. There has been a lively debate since the decision among both originalists and non-originalists about how originalist the opinion and how originalist the actual test is. As you say, the test looks to text, history, and tradition. Certainly, the text can be interpreted as an originalist by what was meant at the time. History certainly is part of an originalist inquiry. Tradition, however, is a little bit different than an appeal to straight originalism. So there are some distinctions between a traditionalist form of interpretation and an originalist form of interpretation. For an originalist, anything that contradicts what the meaning would have been at the time the provision was ratified can't shed light, can't overcome the original meaning. That assumes, of course, that we can decipher and discover that original meaning. But for a traditionalist, there can be later practices that shed light on the meaning of the Constitution. In other words, it's not fixed at the time of 1791. It can be elucidated. It can be what some scholars call liquidated throughout traditions, throughout the discovery of traditions of the American people and their practices. And Justice Thomas, in the Bruen decision, when he announces that new test, seems to suggest that traditions and practices of the American people can also shed light on the meaning of the Second Amendment. In other words, that it's not totally fixed by whatever happened in 1791.
Before we let you go, maybe we could get your thoughts on the relative strengths and weaknesses of using originalism with regard to the Second Amendment.
Yeah, so there is a long-standing interpretive debate between those who adhere to an originalist theory of interpretation and those who dismiss it, or those who adopt more pluralist theories of constitutional interpretation. There have been many critiques of originalism. Some of those say that originalism faces problems both of recovery and of justification. So the problems of recovery say it's really hard to understand what the original meaning of provisions would have been 250 years ago. That we cannot get into the minds of the founders or the framers or the ratifying generation, that they had totally different beliefs, that we don't inhabit the same moral or normative universe, and oftentimes we don't inhabit the same factual universe, that they held false factual beliefs about many things, including the earth and the status of women and enslaved people. And yet, even if those obstacles can be overcome, even if we can decipher original meaning, even if there is such a thing as one original meaning, there are still problems of justification. So if we get past the hurdles of recovery, there are some who say that originalism is flawed because it requires us to give deference to those who drafted and ratified the Constitution, who were exclusively white men, and many of whom were slaveholders themselves, and who, as I mentioned, held beliefs that we no longer think are tenable, who held beliefs about who should have power and who shouldn't have power that are no longer consistent with American values and American morals. And so there's the question of whether or not, even if we can recover that, we should still be deferring to that today. On the other hand, you said there are some strengths of an originalist interpretive framework. And some of those are that it's fairly intuitive, that if you have a written constitution, in the same way that you might try to figure out what somebody meant when they wrote you a letter. If you found a letter, you would appeal to what that person thought words were doing. You might look up a dictionary from the time if you found an old letter and think about what those words would have meant to the person that was writing the letter. Many people use this analogy when they talk about the Constitution. So there is an intuitive appeal that these words were written at a certain time in the past, and we have to know what those words meant at that time to know what meaning was conveyed. There is also the notion that deferring to the past, deferring to the original public meaning, actually lends democratic credence to the Constitution, because it is taking, at least theoretically, taking power away from judges today to impose their own policy preferences, and saying the people that ratified the Constitution, that was a democratic act. Judges, federal judges, are unelected and unaccountable. And so if there should be constitutional change, it should come from the popular branches, or it should come from the people themselves, and not from judges that are updating the Constitution based on their policy preferences.
Well, we'll let the viewers weigh those pros and cons, but Professor Charles, thank you for your time today and for the insights.
Thank you.